Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. On today's court docket in the Idaho 4 case, 3 documents appeared on the public docket. And today is December 20th, 2024. One of these we have been waiting for 8 days. It is the defendant's December 13th, 2024, 20th Supplemental Request for Discovery. It says here, please take notice that the undersigned, pursuant to Rule 16 of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States, and also Article 1, Section 1, 2, 13, and 17 of the Constitution of the State of Idaho. This is all of the legal authority that Mr. Kohberger is citing in coming before the court and serving his now 20th supplemental request for discovery. Now, this does not mean he's going back 20 times to the state and asking for the same thing. This means there was a first discovery request, and typically what happens is that a party will look at some of the information that has been submitted, and then from there they may say, well, I'm going to need to get some additional evidence, and so that might be listed in the first supplemental request for discovery, or as things go on in the case and more facts are uncovered, that's when there will be a supplemental request for discovery. But I've heard in the community that people have said, well, the state of Idaho is not turning things over. No, that would be the subject of a motion to compel. If something was asked for and there was an objection raised that it's not discoverable, you try to work it out. If you can't, then you file a motion to compel with the court, to try to compel the court to order the other side to turn it over. So now this 20th supplemental request for discovery tells us that there have been a total of 21 discovery requests that have been served in this case by Mr. Kohberger upon the state of Idaho. Now, after citing to the legal authority as he did on page 1, we go now to page 2. And it says here, it continues on, pursuant to discovery, an inspection of all materials discoverable by defendant per ICR 16B18 and the aforementioned constitutional provisions. Now, I have not seen, I don't think this term before, inspection of all materials. So sometimes when you serve a request for discovery, it's to, let's just say, you have insurance, your house burns down, you file a claim with the insurance company might want to send an inspector into the house with what's remaining of it to inspect it. They need to ask for permission from you to do so. That might be an inspection upon land or property. This is not telling us, discovery and inspection of all materials, what that might be. But I have not seen this term before in any of these prior discovery requests. He goes on, inspection of all materials discoverable by defendant per ICR 16B 1 through 8 and the aforementioned constitutional provisions, including but not limited to the following information, evidence, and materials outlined, and here we go, in Exhibit S as in Sam. Why Exhibit S? Because the first 21 requests for discovery, the first and then the 19 supplemental that followed, there was a schedule in Exhibit A through R. So now we're up to Exhibit S. Exhibit S will be filed conventionally, meaning it will be in person and delivered under seal on December 13th, 2024. This is rather interesting. And I'm wondering, I'm just throwing out my opinion here, was the fact that whatever is in this a little bit different type of discovery request necessitated an in-person filing conventionally because the information was so apparently sensitive it couldn't be filed via email or online. But in any event, this looks a little bit different. I provided a link in the description to this podcast episode so that you can pull it up and view it for yourself. This is dated the 13th of December, 2024. Ann C. Taylor is who signed this discovery request. And I want to point out at this time, the state has been accused very much of filing things under seal, and they absolutely have. But it's really both sides who, in my opinion, has led to this enormous amount of things that are under seal and kept off the public docket. I give my opinion as always pursuant to the First Amendment, freedom of speech, freedom of the press. This is one discovery request that I would really like to see what is listed on Exhibit S, because it's a little bit different, as I've said, for the reasons that we just went over, than what we've seen before. There were two more things that were filed, both of them on the 18th that we talked about in a prior episode of the IndieZone. These are the state's filings. Stipulated motion to seal state supplemental response to request for discovery regarding expert testimony. So this is something, it looks like entirely different than the 20th discovery request. It says here, comes now the state of Idaho by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to and gives the legal authority for an order sealing the state's supplemental response to request for discovery regarding expert testimony and all attached exhibits herein. This is stipulated to, so this means that the state had to contact the defense and ask if there was any objections to filing these things under seal, and the defense, who filed many things under seal themselves, had no objection. Now we see the same 5 misnumbered reasons we have seen in this case before once again. The reasons why these exhibits, all of this information regarding expert testimony, needs to be under seal and therefore kept out of the public domain is because release or docketing, or release or disclosures onto the public docket, not might, not could, but would, meaning shall. This will happen. 1. Interfere with enforcement proceedings. 2. Deprive a person of a right for a fair trial or an impartial adjudication. That appears to be referencing Mr. Kohberger's constitutional right for a fair trial. Now we go to page number 3 and we see the misnumbering again. Second number 2 should be 3. Constitute an unwarranted invasion of personal property. Number 3 should be 4. Disclose the identity of a confidential source. And or 4 should be 5. Disclose investigative techniques and procedures. No supporting details are provided here. How disclosure would lead to all of these or one of these ills. It says and or in between. And here we see the statement. The undersigned, and that is Ashley Jennings, she is the senior deputy prosecuting attorney out of Ada County, has contacted the defense and they have no objection to this motion to keep this information document regarding expert testimony under seal. The state respectfully requests that the court seal from public disclosure this supplemental request. All of the information that constitutes the meat and potatoes of what the state has now produced. That is under seal. Finally, the third document that was produced today is the stipulated motion to seal the state's motion to extend no contact orders and amended no contact orders. Let's read this. This was just docketed on the 18th. It turned up yesterday, the 19th, in the case status summary that the clerk of court maintains. It says, comes now the state of Idaho by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to, and they give the legal authority, for an order sealing state's motion to extend no contact orders and amended no contact orders herein. So it's two things. they have produced, it could be in one filing, but it's two separate items. It is number one, the motion to extend the no contact orders. There are no contact orders, as we've stated when we went over these filings on the docket yesterday, that were entered way back in January of 2023 in the case. So they're looking to extend possibly those no contact orders. We don't know because they were initials is what's given in this second, the amended no contact orders. Herein, because release or disclosure would, and here we see again the same 5 misnumbered reasons. 1, interfere with enforcement proceedings. 2, deprive a person of a right to a fair trial or an impartial adjudication. Second, number 2 should be 3, constitute an unwarranted invasion of personal privacy. 3 should be 4, disclose the identity of a confidential source and or for number 5, we have to go to the next page. And as I said, we've seen these misnumbered reasons over and over again in both of these filings. Number 4 should be 5, disclose investigative techniques and procedures. And here we see, this is Bill Thompson who has filed this. The undersigned has contacted the defense and they have no objection to this motion. And so they're asking here for permission to have those items, those 2 items regarding the motion to extend the no contact orders and then the no contact orders themselves, the amended no contact orders that would include this new date or dates. If you would like to review these documents, please go to the link that I have provided for you in the description to this podcast episode, and you can review them for yourself. As always, thank you for joining us here today.